union and the employees are at odds, and the employees and the company are at odds, and the company and the union are sort of at odds because the company's upset that the employees walked off the job without the union being involved in the situation. And while that strike was ongoing, I had a chance to meet with the attorneys representing the company, who was a small 8-person employment law firm down in Houston, Texas. And I found their job to be really interesting, especially at that time, dealing with that dynamic of the conflict within the workplace and how that situation got resolved. And the workers came back to work a week later. There were no terminations. Everyone moved on. It was essentially a pretty testy situation that got resolved, and it was interesting to see that process play out. So looking for something to do after my first year of law school, I sent them a letter asking if there was anything I could do to help them after my first year, and they extended an offer for me to come down and be a research clerk for them after my first year. So I went down to Houston, a place I'd never been before, and enjoyed the nice 100-degree summers and spent a lot of times doing research for them, and I found it to be absolutely fascinating. I like doing it from the management end, doing a lot of helping them with a lot of training. I remember editing a lot of handbooks, and of course doing a lot of busy research and writing. I enjoyed that experience tremendously. I liked the people that I worked with, but I didn't really want to go to Texas. So when I got back to law school, I applied for law firms that had labor and employment law practice, and I just so happened to end up with Lippert Mendelsohn, which is here in San Francisco. And I kind of had my mindset of going to California because based on everything I'd heard from the other attorneys, and I believe this is undoubtedly true today, California really is at the forefront of all of the major issues in labor and employment law. It's a very progressive state and has very unique labor and employment laws, and I think we do set the trend for most of the nation when it comes to labor and employment law. So, with that in mind, I was fortunate enough to get the offer as a summer associate. I enjoyed the experience, and I got offered a job out of law school, and I've been there ever since. That was started in the fall of 2004. So I can only speak to you from the perspective of my law firm and my practice. Every law firm is a little bit different, but as a junior associate in a large law firm, obviously you do spend a lot of time doing research and writing, but I really think that time is invaluable because some of the law, well, let's face it, most of this stuff is not necessarily intuitive. You aren't just born with a sudden knowledge of what the prima facie case of prima facie elements of discrimination are, or what the McDonnell-Douglas test is. You need to do that research and writing so you do know how to practice. And writing is an essential component of the legal profession. And legal writing is much different than the writing, any other kind of writing. Undergraduate, if you're an arts and sciences major, you probably injured your, I guess, dating myself here, but your finger from writing out the blue book so long, but now you've got the laptops. You spend so much time writing, and when you go into the legal profession, it's just an entirely different sort of writing. So it's good to get that under your belt at an early stage, and undoubtedly you will. I did get a lot of experience as a first and second year associate, being able to put on witnesses and do some administrative hearings. For example, 8 months after I passed the bar, I did a whole hearing before the National Labor Relations Board administrative law judge here in San Francisco pertaining to the legality of a union election and reported unfair labor practice charges associated with that election. I was able to put on witnesses at an arbitration. I was able to prepare witnesses for deposition. So I was able to get my feet wet at a fairly early stage, but of course also doing more of the meat and potatoes junior associate work that's there. And of course also involved in that process is writing employee handbooks, helping edit, revise company policies and procedures and the like. And I think eventually over time, within 2 or 3 years, you begin to have more, and once you become more acclimated with the law, and once you, for lack of a better word, know what you're talking about, you get an opportunity to deal firsthand with clients. And to me, and that really is the most rewarding aspect of the job. Is everyone at this table will tell you the best part about our profession, our job, is dealing with people. Everybody here has been employed by somebody at some point in time. Everybody here knows what the working relationship is. There's not one case you'll come across where there isn't a person involved with an interesting story to tell. Every single day is different. It's kind of a bummer that when you're an attorney, nobody calls attorneys for fun. It's not something people particularly enjoy. They call you because they need help and they need assistance. And it's gratifying to be the person on the other end of the line or across the table who can provide that assistance to them. And I think, a few years out of law school, on my end, I began to have more regular interaction with clients, specifically taking daily calls when an issue arises, helping them through, advising them through processes like collective bargaining and training for their employees. And in that same time frame, I began to take on more of a lead role in cases, taking depositions, writing summary judgment motions on my own. Another factor of big employment law firms to keep that you need to keep in mind is, of course, there are different billing rates for people, and the more senior you are, the more expensive it is. So clients really do like to talk with associates who know what they're doing because, number one, associates tend to be more available, and associates also are less expensive to work with. So you do get a lot of first-hand interaction with clients through that stage of your career. And 5 or 6 years later, I was able to do a bench trial, a pretty big bench trial on my own, argue appellate matters autonomously. And I became a shareholder just this year, 6.5 years after I graduated law school. And really the work remains very similar in terms of the legal professional aspects of it. Still a lot of counseling, still a lot of training, litigation work. I tend to do a little more traditional labor work than many employment law attorneys. In the Bay Area, there's still several unionized workplaces here. So I will handle collective bargaining. I will handle arbitrations involving disputes over interpretation of the collective bargaining process or the collective bargaining agreement. I'll handle issues pertaining to NLRB elections, those sorts of things. But one thing that has become more of a part of my job, again, is the business aspect of it, just like Monique mentioned. And as Galen referred to earlier, when companies retain you, they are, especially this day and age, they want to make sure that they are getting as good a value as possible. So it's important to be in constant communication with the client about what the realistic expenses of a particular case are, how much time and energy will be necessary. Alert them in terms of what the existing costs are, what they are to be going forward, what unexpected developments are out there, what are the recent developments in the law. These are all things that you do need to maintain constant communication with the client over. And one thing that I think is true throughout any area of any time of your practice, it's really important to monitor the law, especially in California. It's ever evolving. Things don't just get rid of the statute and remain the same. There are several critical issues that remain unresolved. I'll just point out one example that I think is really a hot issue in employment law is the California Supreme Court is currently deciding to what extent an employer is required to either provide or ensure that non-exempt employees take half-hour meal breaks for every 5 hours worked. If it's a matter of merely providing meal breaks without making certain the employees take that time, then it's a much easier situation for the employer to manage. However, if you're dealing with ensuring that it's a half-hour meal break, then you run into very significant compliance issues, and plus it creates a lot of class action exposure, especially in specific industries. Like, for example, bore you too much with details, but you know, the trucking industry where your employees work off-site and your supervisors don't have their eye on them, and there's no break room or place on the wall for people to clock in and clock out during their lunch breaks. How do you monitor, how do you make sure that your employees take those meal breaks without being distracted? You know, the 30-minute meal break is supposed to be the employee's own time, where they're not interfered with, they're free to do whatever they please. How do you ensure that people don't do that? How do you ensure they take the full 30 minutes and they're not answering work calls or they feel confined to a particular area? These are the sort of things we counsel them on a daily basis. Not to say that it's impossible to comply with the latter interpretation of the law and ensuring that there are meal breaks, but it certainly becomes more challenging from that aspect. So, in any event, to wind this up, again, I think if you are really interested in dealing with people, with solving problems, and enjoying your career, I think labor and employment law is a fantastic field to enter. I encourage you all to do it, and also to the extent you're looking for opportunities, I would just encourage you all to keep an open mind and try to get in any way that you can, whether it is working on a plaintiff side firm or a management side firm, governmental agency, doing clinics, pro bono work, whatever it is. I strongly encourage you to do it because it is a fantastic practice.
Do we have more questions? Let me just pose one. Go ahead.
It's not a question.
Go ahead.
So, Michael is exactly right in terms of just how the law is constantly evolving, definitely so much so here.